We're often asked what is important to know about tripping hazards. And obviously that depends, I guess, if you're the premise owner or you're the person that has just tripped. With respect to the law, and the law is clear on these cases, is that there are certain tripping hazards that can be considered non-negligent. The first analysis that's made by courts is whether the tripping hazard is what we call de minimis. De minimis means that it's so small that a reasonable person would not have corrected the problem. Now, generally speaking, and oftentimes we'll make arguments, that's a jury decision as opposed to a judge's decision. But there are certain situations in New York State that our courts have looked at the grade difference that someone tripped on and make a determination as a matter of law that it's de minimis. The next issue that we have to look at is under our court system is whether a tripping hazard is what is called open and obvious. An open and obvious condition is just that. If there is a large tripping hazard and it's bright light out and you should have seen it and walk into it and trip, they will make, when I say they, the defendants and the defendants' insurance companies and their attorneys, will make an argument that your claim should either be denied or reduced by the fact that the tripping hazard was open and obvious. Again, open and obvious has to do with a lot of factors. Number one would be lighting in the area. Number two would be distractions in the area. Whether or not there would be distractions that would take your eyesight away from the area where the tripping hazard was located. And even if it is open and obvious, that does not mean that the premise owner is not negligent. There are other theories that we can come in with that will overcome any motion for summary judgment in that regard. So if you are involved in a trip and fall incident, please give us a call.